Okay, well, good afternoon, everybody, and welcome to this IT governance webinar on EU GDPR and you. This particular seminar is on the requirements for marketing. My name's Richard Campo, and I'm part of the Governance, Risk and Compliance team within IT Governance. I'm a GRC consultant. And my focus on my specialist area is data protection. And this webinar, we're going to be here for the next 45 minutes. There's going to be around 15 minutes for questions at the end. So you can use the chat functionality of GoToMeeting. So you should be able to see that. And if you have questions as I'm speaking along the way, please do write those questions. I'll make sure I have a look and get to as many of those questions within the time we have available in the last 15 minutes of this particular session. So, as I say, my name is Richard Campo. I'm a governance, risk and compliance consultant. I look after the data protection and information security aspects of our work. My background is as an auditor. I'm a lead auditor. I'm also a lead implementer on this Information Security Standard 27001. So I've worked on over 40 or 50 implementations of these good practice frameworks for information security. I've also worked very much on GDPR compliance, that's the General Data Protection Regulation. Looking at how to audit and how to transition your existing compliance framework to meet the requirements. There's some really specific requirements for GDPR. So I help organisations with those gap analysis and the recommendations to become GDPR compliant. I also do risk management and I embed that into corporate frameworks too. So that's a little bit about me. A couple of slides quickly on IT governance. It's the GRC Governance, Risk and Compliance one-stop shop. So IT governance has this cyber resilience. We do penetration testing of networks. We have a raft of training courses. I run one of the first courses, I think, that has been accredited for data protection. I run a data protection foundation, GDPR foundation course, a one-day course, and that leads into a 4-day GDPR or data protection practitioner course as well. So there will be some slides at the end where, if you're interested, we can provide further information and links to how you might apply for those courses. We also offer books and toolkits as well. So we also have a toolkit on GDPR, which includes all the sort of things you might expect to see, which is your policies, your processes, a great privacy impact assessment sheet as well, which is one of these new mandatory requirements. So there's a whole raft of good stuff there, lots of collateral that might help you and your organisation become GDPR compliant. A quick overview of today's agenda. I'm going to, for some of you, this might be new, but for those of you that are new to this, I'm going to cover a quick overview of the regulatory landscape. We're going to be covering the territorial scope, the material scope of the regulation. We're going to be looking at some of the penalties, which some of you may know about already. We're going to be looking at privacy notices, the information that you need to share and present to your data subjects at the point of collecting any information. We're looking at the rights of the data subjects, the consents, data processing, and we're going to be applying that from a marketing perspective too, and then looking at international transfers as well. It's probably worth just stepping back for a moment to say, where are we now and where are we heading in terms of the European law? You may be aware there are two types of regulation or legislation across Europe at the European Union. There's the directives, which has just been replaced. We have this European directive now for data protection, which we're moving away from. The directive was almost 20 years old, which is why we have this new data protection regulation to bring us up to speed with this new social media, with the technology, digital technology. So the directive, which was set in '95, was interpreted and enacted into law. And in the UK, we had the Data Protection Act in 1998. The regulation, though, the difference there with the regulation is it's immediately applicable in every member state. So this GDPR has now been signed off. Just look quick at the next slide here. The regulation came into force on the 24th of May 2016. And it will apply from the 25th of May 2018. So basically it means all member states across Europe will have to adhere to this new regulation. We have 2 years. There's this kind of what they call a sunrise period to get ready. That means the supervisory authorities and all the organisations, the controllers and the processors across Europe now have 2 years. The clock starts ticking now to get ready for this new regulation. It will become the fines will start kicking in 2 years from now. So if you're not compliant now, if you're not started to think about what the sort of things you need to do in terms of becoming GDPR compliant, the earlier the better. And we're going to be covering some of those areas where you might need to focus on as well. There's the link to the final text of the regulation there on that slide. So if you haven't seen it, do take a look at that. We'll be covering some of the key elements of it now. What I'm going to do now is build up this slide. This is almost like the 5,000-foot view of the regulation at a very high level point. The key thing here, these words that we've got, the data controller, you need to understand, if you're not familiar with this terminology, these are all the definitions that are within the regulation. There is a section there, Article 4, which sort of outlines what each of these are. So I'm going to go through a few of them with you now. So the data controller, if you're the organisation or the entity that determines the manner and the purpose for processing and collecting personal data, then you're a data controller. As you can see there, you've got specific obligations there from the supervisory authority. In the UK, that's the Information Commissioner's Office. Above the Commissioner, across every member state, there's a European Data Protection Board. So if you're familiar with the current data protection world, we have the Working Party, which is like a representative from every member state that meets at that European level to discuss what's working, what isn't working. They also provide advice and guidance. They also provide a code of practice as well. So we expect more to be coming from the authorities in due course. It's the supervisory authorities are the ones that will be dishing out the fines as well. We'll be talking more about the fines in a moment. The data subject, well, that's a living natural person. So if you're collecting information from individuals, the data subjects, and that information is personally identifiable, then that means the GDPR now starts to take effect. There are 8 powerful rights built into this regulation, and we'll be looking at those in due course later on in this presentation. So if you're collecting information, data subjects, you need to, the regulation kicks in. There are third parties. Third parties are those working on behalf of the data subject. So these are maybe like lawyers or solicitors, or maybe members of the family that are working by proxy on your behalf. So they may have access to your information or may be able to ask for information on your behalf. There are third countries. Now, this is a third country under the GDPR is anywhere outside of the European Union or the European Economic Area. There is this prohibition. You can't send data outside of Europe, the European Union, unless you meet certain conditions. Those conditions include whether there is an adequate country, and whether it's an adequate country is determined by the European Commission, whether the laws in the jurisdictions you want to send the data to reflect roughly the laws that we have in Europe. So that means there's the rights and freedoms, the human rights, the right to a private life. So we're looking for those laws. If you're sending data outside of Europe, we need to make certain that those countries have similar laws in place. If they don't, you'll need to put in a legal contract in place with the entity you're sending the data to, or you may have binding corporate rules, which is all the members of your group, your organization, are bound by certain corporate rules which have been approved by the supervisory authority. Now, some data controllers you may be sharing some of your information, or some of the processing, you've outsourced it to a data processor. The definition of processor is if they're acting in accordance with the data controller's requirements. So in this case, a common example there would be a HR payroll. You're not doing the payroll yourself, you're outsourcing that to another supplier, and they're acting in accordance to pay staff wages. A cloud provider may also be a data processor too. So if they're acting in accordance with your requirements, then they're a data processor. Now, the interesting thing in with this new regulation is both processors and data controllers are now liable under the regulation. Under the old directive, under the old Data Protection Act, it was only the data controller that would be fined. So if you are a data controller or a data processor, you need to really take note of what this regulation requires, because as you can see there, the supervisory authority may come down and investigate any data breaches if the breach came from the data processor. So they are now in scope, so the light of the law, the power of the law can sort of now focus on the processor. So that's one of the big changes from the old directive. I'm going to move on to the next slide here. So Articles 1 to 3 of the regulation sort of set out the who, the what and the where. So just to recap there, so it talks about a natural person. That's defined as a living individual. These natural persons, we as data subjects, have some 8 powerful rights about the protection of our data, about the protection of the processing of the data, and about the movement of our data across Europe. The material scope, therefore, includes all the information about the data subjects, whether it's processed wholly or partly by automated means. In other words, that means if it's on a computer, it's being processed in a sort of a digital system, then the GDPR kicks in. It also includes paper records and information as part of a filing system, or at least a structured filing system, or it's intended to be. So if you're processing information, you're using forms, the point of collection, you're asking a data subject to fill in their form, their name, their address, etc. And that's then going to be uploaded or scanned into a system. Those forms, the paper records, also fall into scope of the GDPR. In terms of the geographic scope, the regulation applies to controllers and processors who are based in the EU, irrespective of where the processing takes place. So if you're based in the UK or in any member states across Europe, and you want to do your processing in the US or in India, and that processing includes the personal data of European citizens, then the GDPR applies. The converse applies as well. So if you're based in the US, or if you're a controller based in India, and you're targeting European citizens for goods or for services, whether a payment's required or not, the GDPR also applies to organisations that are outside of the EU. So it has a very broad, far-reaching territorial scope now. So if you're processing European citizens' data and it's personal data, then it's likely that the GDPR will apply. Another sort of headline news here in terms of the GDPR is the remedies, liabilities and penalties. As a data subject, we have various powerful rights. We have the right to complain judicial remedy against the controller or processor. We have the right to compensation from both the processor or controller. Especially the law doesn't quite define it, but it talks about if the subject has suffered material or non-material damage, then we can get compensation from both the controller and the processor. So that's something to watch out for now. So the right to compensation. Article 83 sets out the requirements for setting out the fines. And on the next couple of slides, you'll see Article 83 talks about that there's a two-tier structure, and it actually tells you which of the areas, which articles you might want to focus in on in your organization to say, look, child's consent, for example. So if you're targeting or marketing children, or you're collecting children's data, there are certain articles in there and specific requirements that talk about child's consent. How do you get child's consent? And your marketing to child, so it talks about getting parental consent or putting controls in place to make sure that children are fully aware of what you're going to be doing with the data. There's also requirements like data protection by design and by default. Now this also applies to your projects and your initiatives and marketing campaigns too. So we're looking at making sure that privacy is built into your processing. So if you're designing a smartphone app, for example, privacy by design means you've thought about the what information you're collecting, whether it's the minimum necessary, how you're going to protect it. It's almost the life cycle of that data that you've got from cradle through to grave, and all the controls are around that to ensure that the rights of the individual there, that the information is protected, and only those that are or authorized to see the information can see it. So that's a very big area. We won't go into much detail today. And data protection by default means that if you're creating a system or an app or any sort of service, that some of those processes, for example on the smartphone, if location services is switched on by default when you first switch on your iPhone or your smartphone. So if GDPR was being applied correctly, then those systems and services should be switched off by default, and it's down to the data subject to switch on the additional systems and services which might breach, well, it has a greater impact on an individual's privacy. Security is key, and cooperation with the data supervisory authorities is key here as well. So these are the conditions here. These articles that I'm presenting on this particular slide are the lower. This is the 2% of your total worldwide annual turnover, or 10 million euros, whichever is greater. These are the articles that you might want to zero in on in terms of watching. Does your current compliance framework have any controls or evidence of processing for these particular controls I'm showing now on this particular slide? So things like the articles, the principles, sorry, which are set in Article 5, which are the principles relating to processing personal data. If there's one thing you need to remember from this presentation, it's those 6 principles, because the principles are the foundation of the law, and the articles and the actual legal obligations kind of stem from those principles. So knowing those principles is really important for the marketeers, for all the teams involved in the processing. Lawfulness of processing also, Article 6 sets out the lawfulness of processing, and we'll be touching that on again in a moment. The law also talks about special categories of data. You may have heard it mentioned as sensitive personal data. The categories there, as you might expect, include things like your health records, any criminal proceedings, ethnicity, religious data. So that sort of data requires an extra special layer of control. Because it's special categories of data. So if that information is disclosed, it's likely to cause more damage and distress to the data individuals. If my health records were disclosed to the wrong people, it's likely more damage would be there. Or if financial information is disclosed, then it's again likely to cause some damage or distress to the individual. So there's that category of special category of data. So you need to know what what falls into that category, and if you're processing it, additional controls need to be applied. The rights of the data subject is the next one. There are 8 powerful rights. We'll touch on them later on in this presentation. And you need to be able to build these rights into your processing, the rights to object, the rights to rectification, the right to be forgotten. That needs to be built into the processes if you're collecting information. And the other key one to watch out for, if you're a multinational organization or you're processing international information, then transfer to third countries. That is likely to attract a high fine if you don't follow the rules and the regulations set out in this regulation, and we'll touch on that again a little bit more further on. As this is specifically focused on marketing, I picked out a few cases, certainly from the UK, where fines have been applied recently. So these are sort of some of the lessons you can learn from or try and build into your process to avoid it happening to you. So in this case, there was a car brokerage company that used public telecommunication services for sending unsolicited direct marketing text messages, and they were fined £30,000 by the ICO. The ICO stands for the Information Commissioner's Office. They're the supervisory authority in the UK. So again, if you're doing direct marketing and you're using text messages, and you're doing that without meeting one of the lawful conditions, consents necessary for a contract, that's likely to be, well, it will be a breach of the regulation. Another case there was a debt management company that again also sent out unwanted marketing text. They were fined €40,000. Now that's based on the current or in the old directive, where the ICO can fine a maximum of £500,000. Now, if we fast forward to 2 years' time to May 2018, when the fines from the GDPR take effect, then you could probably add another tens of thousands to that, because they can fine up to a maximum of 20 million euros for breaches of the GDPR. Another example there is a company that made nuisance calls, 1.6 million nuisance calls selling solar panels. They were fined 60,000. So again, it's this direct marketing. If you haven't got consent, then the GDPR is likely to kick in, and these much larger fines that we're seeing here are likely to follow through as well. The ICO, not only the fines, they also have the power to stop processing. So in this case, the final example there was a stop order from a company that was falsely claiming it was phoning people as part of a lifestyle survey, perhaps a process known as sugging. So it's for organisations that are trying to sort of work their way around the law. They're going to try and catch that too. So it's really, the idea is to follow this good practice and meet your obligations. So what are the privacy principles? If you've not seen them before, there are 6, and essentially they're the essence of the law. You need to know these and build them into your processing, into your operations, into your design of new systems and marketing initiatives. And we're going to go through them quickly with you now. The first principle there, process lawfully and fairly. Lawfully, there are certain conditions that Article 6 and Article 9 of the regulation talks about what lawful means. Lawful, you need to be able to tick one of those requirements set out in Article 6 and 9. So things like, have you got consent? Is it necessary for a contract? You need to collect that. And what does fairly mean? Well, fairly is this privacy notice. You need to have some form of either a fair processing statement, a privacy policy, and ideally a just-in-time notice, which is at the point of collection, either a pop-up box or some sort of a tick box appears, which says, hey, we're collecting your data. Do you understand what we're going to use it for? So either a quick link or a pop-up box, a bit like the cookie law bubbles that sometimes you see saying we're collecting, we're placing cookies on your laptop. Do you agree? So we're going to see a move towards that in the online digital space, I expect, to demonstrate compliance with that first principle, process fairly and lawfully. The other principle there, principle 2, collected for specific, explicit, legitimate purposes. You've got to be able to articulate what the purposes of the collection are. And it's got to relate back to principle 1. You've got to tell us what those purposes are. So your privacy policy or the fair processing notice needs to outline who you are as a controller, who to contact for me to be able to exercise my rights, and the purposes of the collection. What are you going to use it for? It's got to be much more explicit and clear than I think some of the privacy policies and notices I've seen previously. So purposes need to be clearly set out from the outset. Principle 3 is all about adequacy, the minimization principles. So often we see marketing campaigns where they're collecting more information than they perhaps need to for the purposes that they're collecting it for. So for example, a competition, it may ask for, or they have previously asked for, name, address, date of birth, and in some cases information like that's not necessary for the competition. So it's really about making the marketeers, the design of your campaigns, think about why do we need the information. If you don't need it and it's not relevant to the purpose, then I'd strip that out from your collection. The fourth principle there is about accuracy and where necessary kept up to date. So if you do have these databases, and this is where I might use the sort of the 3 V's of big data. Here I'm thinking about the volume. How many records do you have being processed? Is it 10, 10,000, a million, 10 million records? So obviously the higher the volume of records of data subjects you've got, the higher, if there's a breach, the fines might be. The second V is about the variety of the data that you're collecting. Again, it goes back to the minimization principle, principle 3. So is it name, address, date of birth, a photograph, medical data? So as again, the more categories of data that you're collecting, the higher the likelihood you can identify somebody from that data set, and also the greater the information you've got, the more damage and distress potentially that could cause as well to the data subject if it's disclosed either accidentally or deliberately to the wrong people. So building into your processes, your campaigns, your systems is a mechanism to ensure you know how accurate that data is, or giving the data subjects a mechanism to update their details, like a portal where I can update if I've moved my address or changed name, etc. A mechanism to update the information, and periodically cleansing it, spring cleaning of that information, if certainly where necessary. So for example, where decisions are being made on it, or you're sending information out on a regular basis, those records need to be kept up to date. Principle 5 is something we do see some organisations fall foul of. It's about keeping information, the records about your data subjects, for as long as necessary. So ideally what we're looking for there is some sort of retention policy or a mechanism within your processing to make sure that if the data was collected for a competition, at the end of the competition you've announced the winner, do you still need to maintain all the information you've collected as a result of that competition? If there are other purposes for that data, then you need to tell the individuals at the point of collection. So if it's going to be used for marketing purposes afterwards, we need to know at the point of entering the competition who you might be sharing that data with. And maintaining, so you need to tell people in your fair processing statements, going back to principle 1, how long that data may be kept for and who it might be shared with. And then finally, the principle 6 is about processed in a manner to maintain integrity and confidentiality. This is all about security, information security. There are loads of controls for this principle. It's the HR security, it's the access controls, supplier management, physical security. So it's all those controls that you need to have in place to demonstrate that the data that you've collected is going to be safe from accidental disclosure or unauthorized access. So those are the 6 privacy principles. There's a sort of a 7th principle which wraps around all of these, which is built into this new GDPR, which is this principle of accountability. So what we'd expect what a supervisory authority to be looking for is, well, who's accountable for that workflow, that work stream, that campaign, that initiative, who's looked at the principles and can sign off to say, yes, I'm happy that all those controls, that all this information is protected. So this level of accountability needs to be built into your processing and processes. From the principles, I've done some sort of mapping. It doesn't immediately look clear when you're reading through the regulation how it all sort of fits together. But Article 5 is the principles, and there they are again, the 6 principles. And when we see Principle 1, for example, I've only mapped it out for this first principle, just so it sort of fits on this slide. Fair and lawful? Well, lawful is set out in Article 6, and it's also set in Article 7, Article 8. So those 3 articles there's also Article 9 about sensitive data, all mapped to demonstrate how you might think about demonstrating lawfulness. Fairness, well, that's also set out in Articles 13 and Article 13 and 14, which sets out what you need to provide at the point of data collection. And the same can be said for the other principles there as well. So there is a very close relationship between the principles and the certain articles within the regulation. About it gives you much more specific guidance, and not even guidance, what you should be doing to demonstrate compliance with the principles. So in terms of fairness, well, Articles 12, 13 and 14 talk about privacy notices and fair processing statements. If you want to demonstrate lawfulness, you need to be able to tick one of these, demonstrate you're meeting one of these provisions set out on that first bullet there. So if you're collecting data, is it necessary? Do you have their consent? Is it required for a contract? Is there a legal obligation you need for the collection of the data? Is it there to protect the vital interest, to save somebody's life? Or is it in the public interest? So you've got to think about your processing to set out. It's got to be one of those. You need to be able to sort of select one or maybe more of those conditions to demonstrate lawfulness of processing. To demonstrate fairness, that you need to take appropriate measures, and you need to be able at the point of collection to demonstrate this fair processing statement. Now, how this is going to work in practice, we don't know specifically yet. They certainly would expect to see a privacy policy, and there's some of the guidance emerging from the ICO, certainly in the UK at least, is this at the point of collection, this just-in-time privacy notice. Usually, for example, if that's an online system you've developed for collecting or marketing to individuals, a little pop-up box might appear saying, please be aware we're using your information for this purpose. Are you happy to proceed and to submit your information? So again, it's just making people, data subjects, aware of what you're doing with their data at the point of submitting that data. Those privacy notices, the ICO's recommendation here, the guidance says it's got to be multi-layered. So you wouldn't want to provide those long privacy policies which go on for 2 or 3 pages. That's more better on your corporate website, on the link at the bottom. There's usually the corporate page, a link to the privacy policy. The Articles 13 sets out some very specific conditions that criteria that need to be into these privacy policies. So you need to look at Articles 13 specifically. But at the point of collection, certainly if it's a paper form, maybe there's some reference to your privacy policy on the bottom of the form, for example. Say, please see our privacy policy, and here's the web address for us to understand more, to give the individual more detail about what you do with their data. In essence, the privacy policies of the past used to be almost written by lawyers. They didn't make much sense to anybody other than a lawyer. So the idea, if you're marketeers, if you can translate those privacy policies into something that people can understand, they're concise, they're clear in their own plain language, and it's easily accessible, then you're heading in the right direction. There are certainly some good practice. We've seen some of the major corporations I've seen recently where they provide very clear policies about what you're collecting, why you're collecting the data, how you're collecting the data, who you might share it with, how long you're keeping the data for, and who to contact in the events that you want to complain, you want data subject wants to exercise their right to be forgotten, for example. So when do you need to provide a fair processing notice? I've added there some recitals there for a bit of background reading, and certainly Articles 13, 14 set out what that notice needs to include. So if you're collecting the information directly from the data subject, PII stands for, on this particular slide, personally identifiable information. So if you're collecting any information about an individual and you're collecting it directly, that privacy notice needs to be presented at the time of collection. If you're not collecting the information directly, you're maybe buying a list from another entity. You need to be able to provide within a reasonable time of obtaining the data, usually as some sort of fair processing statement. And here it could be if you're at the first point of communication with that data subject. So if you've bought a list and then you're starting to use that to market, or you've got a particular campaign to the data subject, you want to be able to have a mechanism for the data subject to have visibility, to be made aware of your fair processing, your privacy policy. Okay, so again, we talked about the various requirements for legitimizing or demonstrating lawfulness. Well, one of them is consent. To me, that's probably one of the weakest conditions, because people can withdraw their consent at any time for processing, and if they do so, You need to have a mechanism to be able for them to be able to withdraw their consent from further marketing, further communication, etc. GDPR defines consent as it must be freely given, specific, informed and unambiguous indication of the data subject's wishes, by which a statement or a clear affirmative action signifies agreement to the processing of personal data. So what does that mean? Well, to meet that requirement, you as the controller must be able to demonstrate the subject has consented to the processing. In other words, the burden of consent is now on the data controller. You need to demonstrate I've given you consent to a particular, for any workflow that you've got. In the old days, it used to be you could turn around to the controller to say, prove to me when you gave me your consent. Well, clearly now the shift is for the data controller to record that consent. So there is a requirement in the GDPR for records of processing. So if you're relying on consent, if your marketing campaigns are designed around consent, then you need to be able to record it and make sure you, if ever in the future somebody withdraws their consent, you've got a field there to show who and how I gave my consent. It talks about the data subject must be able to withdraw that consent at any time. So normally that's the channel or the mechanism that I normally give my consent. So if it's online, then I'm likely to go online to say I want to withdraw my consent. How am I going to do that? What kind of mechanism do you give me? If it's over the telephone, for example, and you've recorded my consent on first discussion with you about collecting my data for a particular system or service, then I'm likely to call again to say I've changed my mind, I want to withdraw my consent. So again, and if it's a paper form, I guess there may be a form for me to fill to say I've withdrawn my consent. So normally the mechanism is the channel that I first engaged you with is likely to be the channel I'll use again to be able to withdraw my consent. Or it could be a mix as well. But it's got to be as easy to withdraw as it is to give it. That's the main sort of a shift there in GDPR. And again, there's the certain recitals that talk about consent. There's article recitals 32, 33, but it was mentioned specifically in Article 4. And I haven't actually mentioned what the difference is between the recitals and the articles. The recitals are, the regulations kind of in two parts. The recitals set out the background, the context, and they provide a lot of very valuable information about how the law has evolved and why it's there, and sort of the information, how it's informed the articles. The articles themselves, so there are 173 recitals, so a lot of background reading about how the law came about in the context. Then there's around 99 articles. The articles are the law. That's the bits that set out you shall, you must, and so non-conformance to an article would be where those fines kick in. Conditions for relying on consent. I'm just going to stay on consent because this is one of those big subjects a lot of marketing campaigns often sort of rely on. The consent should cover all the processing activities carried out for the same purpose or purposes. So again, it goes back to principle 2 about knowing what's the purpose of the information that you're collecting, and that consent needs to be matched exactly to the purpose. If you've got a purpose and I haven't given my consent to that purpose, then you may be in breach of the regulation. If you're processing for multiple purposes, then again, consent must be given for all of them. So in some cases you may be able to design your marketing around, here are the purposes of collection, and maybe I can consent to some or none or one or two, so I should be able to pick and choose what I'm giving my consent to. Remember, privacy is all about, if we ask what's the definition of privacy, most people would say it's about being able to control the information that I give to another individual, what I want to keep to myself, private, and what I want to be able to share for a particular service. So being able to be that specific for the purpose is really getting more aligned with the gist of what privacy actually means. If there are some very specific rules that apply to children, so how would you demonstrate you've got consent? If you are marketing and the marketing is adult services that are not really designed for children, then how are you going to demonstrate or make sure that children can't access the systems that you've got, the competitions or the services? So you need to be able to demonstrate to comply here how you might verify the age or how you might seek parental consent if any of your marketing is targeting children. Consent here, it says it should not be considered freely given if the data subject has no genuine or free choice. So if I can't get the service, unless I give my consent, then that's not really a good condition for relying on it. It may be necessary for a contract, or it may be there to save my life, well, that's fine. But if there's a certain sort of a direct required that I can't get what I need without giving consent, then that's not freely given. So how do you demonstrate compliance then with this particular piece? Well, you can't rely on silence, inactivity, or pre-ticked boxes. That's kind of a no-go. In the past, that may have sort of washed, but not anymore, not under the new GDPR. So silence, if it's on the telephone and you've asked a question, do we have your consent, and you hear silence, that's not a demonstration of consent. Inactivity also, or pre-tick boxes. So for the marketers that used to do the opt-in, opt-out, tick here, don't tick, and it's got to be much clearer in the way you capture consent now. We also need to demonstrate you've got a policy or process in place about how to inform me how I might withdraw my consent. So again, that might be mentioned in your privacy policy or in the fair processing statement to the point of collection. If you're relying on my consent and I want to change my mind, you need to tell me how I might be able to withdraw my consent. And also, if the purpose changes, how do you communicate that change of purpose back to the data subject? Specifically, that purpose is something I wouldn't reasonably expect, as the data subject wouldn't reasonably expect. So there needs to be a mechanism for looping back to the data subjects. If you've collected their email or contact details, often we see that as an email that goes out to everybody saying, if anything's changed, please let us know, and we'll update our records. Maybe it's an online system, you've given them an ID and password to change their details or reconsent. So that's what we're looking for there. The idea there is if you can link your privacy policy to tools like a portal or something that can enable individuals to control how the information is used or shared, the better. So we're going to quickly talk about the rights of the data subjects. There they are. These are the 8 rights of the data subjects: the right to be informed, the right of access, the right to rectification, erasure, restrict processing, portability, the right to object, and the right to rights in relation to automated decision making and profiling. Data subjects can object at any time to processing, unless you can demonstrate legitimate grounds. Then I may be able to say, well, stop processing unless there's a legitimate interest or a legal obligation that you need to have my data. Data subjects have the right to object to any use of data for direct marketing or profiling. So again, where are those mechanisms for an individual to opt out? If you're processing data for scientific or historical purposes, then we can still have a right to object to the processing for that data unless it's necessary for carried out for reasons of public interest. Profiling is something that, or automated decision making. So if you are profiling, you're looking at sort of personal preferences, interests, behaviors, location movements. We need to be told what profiling you're doing and how I might be able to object to that profiling. And again, it's going back to that principle number 1 about the privacy policy to notify data subjects what you might be doing with that data at the point of collection. If you are doing international marketing and transfers of data, then this is where the conditions about transferring data outside of the European Union kick in. Or if you're targeting, you're outside of the European already, you're based outside of Europe, and you're targeting European citizens' data, that would also be maybe, if it's a systematic collection of data from European citizens, that would be seen as a data transfer. So certain very clear requirements are set out you need to have in place. So finally then, in the last minute here, is a quick summary to some of the mechanisms there, method of communication there. For example, live calls, and you're calling a data subject. Then you need to be able to screen. Certainly in the UK, we have this telephone preference service, and you've got to be able to give the point when you first the subject answers the call, the option to opt out of any marketing or to be suppressed from any further marketing too. If you're recording the calls, often we hear the message is going to be recorded for training or sort of fraud purposes, prevention of crime, detection of crime. If you're recording the calls, again, you've got to at least mention that you're recording the call and the purposes for recording the call. And again, how long you're going to keep those records for, etc. That all needs to be sort of explained at some point in that fair processing statement. If you're using emails or texts, we saw several breaches of the Data Protection Act earlier, which attracted those fines. This is where most organisations tend to get it wrong. Well, again, if you're using emails or text, you must have the data subject must have given their consent. So I'm going to open this up now for questions now. So the last 15 minutes, are there any questions coming through? I'd be happy to answer any sort of questions there on the GDPR. So as those questions are coming in, if there are any, a quick summary of the Data Protection Act. It is a complete overhaul of the Data Protection Directive and the framework, and it covers all forms of PI, and it is a broader scope of what personally identifiable information includes: biometric data, genetic data, location data. It also applies to all member states across the European Union. It's now one law that all member states, so it's harmonizing the way the laws are working, so the data protection law. In the past, it used to be a patchwork quilt of the various different acts, so this is an attempt to streamline that. And it applies to all organisations, as I say, just to that if you're processing European citizens' data, no matter where you're based. Some powerful rights, higher fines, and the rights of data subjects, and how we can take compensation. So I'm going to have a quick look at the questions now. There's some great questions coming through. There's certainly, yes, a question there. The slides will be made available following the session, so I think I will ask the support team will have a record of those that have registered, so we should be able to make the slides probably available tomorrow, I expect, when we can get that out to you. How are you, another question there, how are organisations supposed to provide evidence that they're meeting these laws? Are organisations going to be audited by the authority, or will be a case they will only be okay? So we haven't talked. There is this requirement now for breach reporting, a mandatory requirement to report breaches to your supervisory authority. At the moment, in most member states, that's a good practice to notify your supervisory authority of a data breach. But in the new regulation, you've now got 72 hours to report a data breach. You only need to report a data breach to the authorities if it would cause significant harm to the data subject. So certainly if you're processing any of that sensitive data and a high volume or a higher variety, then I would certainly recommend you have a process in place that you're able to detect a breach, ideally prevent the breach, and record what you've done. So certainly the cases that we've seen in the news recently, you've got to know what you're doing with it, and there's also a requirement for you to communicate not only to the supervisory authority of the breaches, but also directly to the data subjects. So if you've got several million people that on that database or system that's been breached, then how are you going to communicate to those individuals? Often we see it hits the news. It might be a newspaper article, it may be there are various channels that you can use to notify breaches. The authorities are not going to audit, they're not going out there, they're not geared up to audit organisations. They have the powers to audit an organisation, they have the powers to audit public bodies at the moment. They have to knock on the door of private companies to say, we'd like to audit you, and if there's somebody has raised a complaint against your organisation because they feel you haven't met one of those principles, you've not met their rights, you haven't provided the information, or you haven't withdrawn consent, or you haven't stopped marketing, then it's likely the regulators will come in and look to audit your organisation. What the the GDPR also has this requirement for accountability. So there's a requirement there for potentially identifying who's responsible for data protection within your organization, and they call this, that there's a role there called the data protection officer, who's there responsible for ensuring that these principles are embedded into your systems, your processes, that you have appropriate technical and organizational controls, that you know what the objectives are of your framework, and then you're measuring those objectives. So the authorities only have, we're not expecting their teams to grow too much, but that's how they may look at that. Another question there is, if we inadvertently give data access to someone to data they shouldn't see, is that disclosure event? Well, potentially yes. We have seen cases of certainly medical records where staff at a hospital have been snooping or peeking into the medical records of people on those databases. So that would be a breakdown of one of your controls. If they're not authorized to see that information, that potentially would be a breach, especially if it could cause damage and distress to the individual. So those databases where people are accessing information when they shouldn't have access to the information, that would be a breach of your one of the controls. So you need to be able to look at your data and ask, well, who's got access to your data and who needs access to the data? Often you find more people than necessary have access to the information. This now moves into access control. So again, we'd be looking for records of, well, what's your access control process? Do you have an access control policy? Is there a process? Who are the authorizers? How do I get access to the data? Do I need to get an authorization from an individual that can say yes or no? And you actually do reviews of who's got access to your systems too. So can you prevent and can you detect access as well? So there's a whole raft of controls in the Information Security Standard 27001 that you might want to think about to prevent that from happening. Another question there from someone about, will data processors be able to be prosecuted before May 2018? Likely no. It only sort of comes into force in May 2018. So if you're a processor, you certainly want to start looking at your control framework and also pushing back on the controllers in some cases. So those that are getting more advanced in their understanding of GDPR is, if the data controller is giving you lots of information, you should be checking that they've done their due diligence. A top tip here is to look into the model clause contracts, which are already in place, which were approved by the European Commission as part of the directive. They're exquisitely written, so there's two types of contracts there. If you Google the model clause contracts, there's controller to controller and the controller to processor. These contracts are literally 3 or 4 pages long, but they're quite well written, very easy to understand, and they set out the requirements of the controllers and the requirements of the processor, the legal obligations. It sets out the definitions and the data being collected. So it's a really good place to start to look at how to protect yourself from a legal perspective, from a contractual perspective too. But you won't be fined prior to May 2018. So how will the enforcement work? If you're based in India, how can I be fined by the EU? Great question. Okay, you need to, if you're based in India, if you're a controller based in India, for example, and you're targeting European citizens' data, then you need to nominate a representative. The regulation requires, if you're targeting citizens in the EU, then you need to demonstrate, you need to appoint a representative. And that representative needs to be in the member states of the countries that you're targeting. So if you're targeting, and it's not also necessary for goods or services or payments, if you're profiling too, you need to nominate a representative, and that representative is there really to act that me as a data subject I can go to, who will sort of handle my complaint, my issue on my behalf. How will you be fined? I don't know the answer yet. I think this is something that perhaps the regulators and the supervisor authorities are looking into already, but already we can see the likes of Google and Facebook. The regulators are certainly chasing those organizations down for breaches of and the right to be forgotten, for example. How those fines will work in actual practice, I don't have that detail yet, and I expect more would emerge over the coming years as even the regulators try to understand how they're going to approach this. But certainly the GDPR has this principle of you need to nominate a representative, and I expect that's that link between your organisation outside the EU and the members and the data subjects in the EU. Will a recording be made available? I believe so, yes. There will be a recording sent out to everybody. I think somebody's answered that already. If someone has their email account compromised and phishing emails are sent to the distribution list, do we need to disclose? You certainly want to do we need to disclose? I think what you're asking there for is, do you need to communicate that your information has been compromised? Certainly, yes. Not only I think that's be good practice to let those that may have been on your systems been compromised, because it may that attack might then attack my system too. So certainly yes, you might want to send out an email to all those that might be impacted. The GDPR does talk about this, about when you communicate to the authorities and when you communicate to the data subjects that might have had their information compromised. So yes, you would need to disclose. Certainly if it's a significant breach and there's a lot of highly sensitive, a high volume or a high variety of data, and it might cause damage and distress. So if that information has been compromised, you need to sort of consider that. So in terms of your processing, it's all risk-based, this regulation. The word risk is mentioned, I think, in over 25 recitals. There are certain requirements like the privacy impact assessment. You would certainly run that particular scenario through your privacy impact assessment to say, well, does it cause damage or distress if that email is disclosed? What's the volume variety of information disclosed? For you as a data controller or your privacy officer or your security officer to say, actually, maybe we should, because if the regulator finds out and you haven't told them, they're likely to take that into consideration, and the fines, if they found out and you haven't told them, the fines are likely to increase because there is this mandatory requirement to communicate. Okay, last 5 minutes. There's lots of questions. What I will try and do, I've got more questions than I have time available to answer here. I'll certainly have a crack at answering all these. I'll make sure that we've got a record of them. And hopefully we can get that out to you too. A couple more questions coming through there. So, do we provide a readiness package for organisations? We do. As IT governance, we have, in terms of the readiness package, we've got the foundation course we have, which goes into much more detail than what we've covered today. Certainly it's a whistle-stop tour through the regulation and all the key articles. We also have the 4-day foundation practitioner course, which builds on that, and we talk about how to build a compliance framework. Some of the frameworks I would recommend you have a look into would be ISO 27001 or the PIMS framework, a British standard, which is BS 112. If you Google those two, and BS 112 might be that's a framework for a personal information management system, which has been aligned with the GDPR. So I've been part of the working group on that, making sure that the specification for that system sets out what you should be doing to demonstrate compliance. We also have toolkits which have all these in place, and that's on the final slide, I think. If I just put that into show now. So these are the sort of things that we have to help organisations with readiness. We also do these gap analysis work as well. So we look at the governance, the data security controls you have in place to give you a sense of where you might want to look at improving your current control framework. There's a question here about text messages. Do you need to get consent prior to the first contact or at the time of first contact? Well, the guidance there is at the time of first contact. So if you are using text messages, hopefully you've obviously got my number somehow to be able to text me. So at that point of collection, that telephone number, I'd expect to say, are you going to be using text messages to communicate with me? Ideally, in your policy or in that fair processing statement, it would be, yes, we will be using texts to get in touch with you. If you want to opt out, hopefully within your text messages, press 9 or stop to opt out of any further communication. That should work. Okay, so we've now reached the end of the session. As I say, we will get the slide deck out to you. I'll try and answer some of the questions as well. I'll start working on that in a moment, and I'm sure our support team will get this out to you if you've registered. If there are any other questions, I'll keep this open for a few more minutes before we close it. I hope that was useful. As I say, any more questions, you can get in touch with IT Governance or with me directly. My details are on the next slide here. So please get in touch, and I hope that was useful. Speak to you soon, and we'll close the call. Thanks for your time.